Sure. My name is Neal Katyal, and I'm a law partner at Hogan Lovells, where I co-direct our appellate practice, and I'm also a law professor at Georgetown. Well, so your job as the advocate is always to win for your client. Okay, so that's why you're doing it. So with Mr. Hamdan, he was freed very soon afterwards, and is living in Yemen and so on. But there was enormous practical impact to that decision. The court said that Common Article 3, the Geneva Conventions, were bound the United States and required essentially the rights indispensable to all civilized peoples to be given to our detainees across the globe. And that changed our torture policy. It ended ghost prisons. There were a lot of things that happened as a result of the Supreme Court's decision in Hamdan. But again, your job is always, as the advocate, not to think about that, but to think about the person who you're representing. And that's true in every case. Obviously, when you're representing the government, it's a different matter when you're in the Solicitor General's office, because the client is the United States. It's not one agency. It's not the White House. It's not the Congress. It's everyone. That's an abstract entity, and so it's different. That entity can't sit in the courtroom and criticize you if they don't like your answer, because there isn't that one entity. But that's what makes the Solicitor General's office so interesting. And kind of, the White House may want you to do a certain thing, the Congress may want you to do another, the agency is a third. It's an enormously interesting position. I remember, the hardest, maybe one of the hardest calls I made was the position to take on whether to patent the human genome. There were so many different positions among the agencies. In that case, the Patent and Trademark Office had issued about 20,000 patents on genes since the Reagan administration. I, as a failed pre-med person, was scared to really get into the gene stuff, but ultimately knew I had to. So I used to go to the NIH on Monday nights and get tutored in genetics and to try and really understand the background of the decision. I wanted to understand the economics of gene patenting. Larry Summers at the White House helped me think that through and had me talk to some experts. It was really, really an amazing constellation of people who were helping me. But at the end of the day, I had to make a decision. Do we seek the invalidation of all these patents? And ultimately I did. It was a position that at the time I got a lot of criticism for, and people said there was no chance that the invalidation would be successful. But again, this is a good example of how if you don't approach things ideologically, but you approach things saying every justice is possibly receptive to your argument, let's figure it out. 9 justices unanimously concluded that human genes can't be patented in the Myriad case. And so it's a good example of trying to walk into court and say, I'm going to talk to every justice, not just the 5 who I think are friendly. Patent law is a really interesting example because it's one of the rare parts of the American system in which we actually have a specialized appellate court that deals with patents, and many of the people on the federal circuit have PhDs in various fields of science, not in kind of German philosophy, but in biochemistry or things like that. So when you're arguing the federal circuit, and I've had some enormously complicated technical cases there, boy, I am going to spend a long, long time understanding all of that science because those judges understand the science. And so there's going to be a bunch of questions that come from that. By contrast, when you're arguing a patent case at the Supreme Court, I think the name of the game is to keep it at a more general level, and in particular to explain why what the Federal Circuit is doing is out of line with the way that standard legal principles are. And if a case is framed that way, it's usually successful because the Federal Circuit, I think, has developed a lot of what look like very patent-specific or Federal Circuit-specific guidelines and rules that the U.S. Supreme Court, I think, sometimes bristles at. And so we've seen the U.S. Supreme Court time and again overrule the Federal Circuit. I just did one in a case called Highmark about attorney's fees and whether or not you could essentially sanction someone for bringing a frivolous case. The Supreme Court looked at it and said, hey, we should apply the same rules here as we do in all the other attorney's fees disputes. There's nothing unique about patent law. There's nothing unique about the Federal Circuit. We should apply the same rules. And so that kind of thinking happens time and again. At the same time, I do think this is a court that is more interested in patents than in any court in our lifetimes. This is a court that understands that the future of the American economy is moving in the direction of intellectual property. We're producing fewer and fewer manufacturing jobs and things, and we're producing a lot more IP. And I think there is a concern reflected in the high number of patent cases that the court has heard that they want to make sure that, that we're getting the system done right. So with respect to kind of the expertise and technology, I guess I have two thoughts. One is you as the advocate better be darn familiar with the technology, whatever it is. I mean, I just argued the Hargis case in December, which has to do with screws and metal fasteners. But darn it, I spent a long time holding those screws in my hand, understanding how they worked and so on, even though at the end of the day it was a trademark case about issue preclusion. But the court may ask you some questions about it and you have to know. From the standpoint of the court, however, I do think that this gets a lot overblown with some, media reporting, oh, the justice doesn't understand cable TV or this or that. I was involved in the Aereo case in which I know there's a lot of hoopla about that. Look, these folks are 9 really, really smart people. I guarantee you they can understand the technology if they think that's relevant to the decision. Oftentimes, the decision isn't turning on the technology, it's rather turning on something else, some standard legal principle. And to the extent it is turning on the technology, I do think this is a court that's adopted a fairly minimalist, go it slow approach because they don't want to stymie the development of new technologies. Well, the Supreme Court grants cases not because of the individual facts, almost always. There are obviously some exceptions. The death penalty cases that are, currently before the court, or, Bush versus Gore, or other extraordinary cases, in which the facts actually matter. But oftentimes, the court's trying to understand what the legal principle should be for the country at large. And they know that, whether one case has sympathetic facts or not, another one might not. And so they got to make the right decision on the law and be cognizant of the old aphorism that hard cases make bad law. So in general, I think the fact that you see some justices who aren't as steeped in the nitty-gritty technical details of a particular technology as it comes to the court, I think just reflects the fact that that's not really what the case is about. The case is about a broader set of principles, and if you as the advocate come in and just want to talk about the facts of your case, you will be run out of that courtroom really quickly.